Good morning, everyone.
Good morning, Your Honor.
I'm not hearing anything. What?
Ms. Crawford, you're singing too.
Why does my thing always go down? There we go. Good morning.
Good morning. All right, this is cause number CR 2023-216, Mills versus State Farm to compel and sanctions being held by Zoom and broadcast over YouTube in order to comply with the open courts doctrine.
Your Honor, Rusty Phenix here on behalf of the plaintiffs in this case, Zachary Reed Mills and Shelley Mills.
Jennifer Crawford here on behalf of State Farm Mutual Automobile Insurance Company.
All right, Mr. Phenix, you may proceed.
Your Honor, I'd like to start with the request for production, and I sent this over and also have provided, I think, hopefully, Ms. Crawford got some exhibits from us, and I really got curious on this because this will be the fourth time we've dealt with this same issue, and I was curious from the standpoint that I don't think this is Ms. Crawford doing this, and I'm convinced now that she's not. It's State Farm that has kind of hijacked her ability to be reasonable in these things. And I'll tell you why I believe this. And you can look at this. The first time we dealt with these issues, or this court dealt with these issues was in Joe Collins, a case that I know the court will remember. We tried it back in 2023, I believe it was, and went to verdict with it. But in that case, represented by Carlos Bolito, and if you look at Exhibit 1, and that's their response. And then if you look at, and let's just look at request for production number 2 on the response that Mr. Bolito has there. That's a different law firm. And the response that Ms. Crawford has made, and really I have another one that another person, Taylor Fisher with Ms. Crawford's firm, has made. But when you read the objections, they're verbatim of what you've dealt with and already compelled in the Crawford case, in the Ashmore case. If you compare those objections, I mean, it's verbatim. And then in the Grigsby case, and now we're dealing with it in the Zachary Mills case. And so we've already done this. In fact, Ms. Crawford's already done this. And so I say all that to say this. I'm not one to really talk about sanctions. I'm really not one to really pursue it. And I certainly, listen, Jennifer Crawford is delightful to deal with. I love her. Okay. I'm getting a little put out with her client. And so I'll just submit all that to the court to consider along with, as we go through these, what we're dealing with here and whether or not the court wants to entertain something. Attorney's fees are attorney's fees, and that's an issue in this case. And so I'm going to probably recover them in the end anyway. So, but whatever the court wants to do, I'll leave that to the court's good discretion. If the court wants to send a message to State Farm and say, hey, why don't you let your lawyers exercise independent judgment and respond to these things, or if we want to keep dealing with this, because there are other State Farm cases that are filed. And so the first one we're looking at is plaintiff's request for production number 2. And what we're seeking is, and I tried to call Ms. Crawford yesterday. I know she was in some hearing or something like that. I couldn't get through to her. But if you look at Exhibit 3, Exhibit 6, and Exhibit 10. It seems like State Farm has amnesia. The court's already ordered that produced, and it has been produced, and it's been compelled in 4 separate orders that are also exhibits to this case to get the claim file. And so the claim file, and really what I'm seeking is, and Ms. Crawford knows what I'm seeking because I've had that conversation with her in other cases, and she was compelled to produce it. I think it was the Ashmore case. And there is a what they call the enterprise claim system. What I just call is claims narratives. I got the first page of those other 2 claim files, and it tells us what happened in the claim and what was considered and the reasons and who did it. And without it, I cannot get. I don't know who to depose. I don't know who's responsible for the decisions, what issues were considered, if anything. For the most part, they're not. But it is the holy grail of information.
What's it called again? Enterprise claim what?
It's the enterprise claim system, but it's the claims narratives. And in the Joe Collins case that we tried, that particular document, I think, was Exhibit 3 that's in the court record on that case. And it generally is about 30 or 40 pages, and it's just the ongoing claims. Whenever anybody does anything on the file, there's something updated that the computer sends out a letter, it updates that. It's a system, and it is easy to get. It's a computer file. It probably take whoever did it 2 minutes to be able to get it and email it over to Ms. Crawford. So with that, I would like the court to overrule their objections, as you have before on 3 separate occasions, to request for production number 2, 3, 4, and 5, and order those documents produced.
All right, Ms. Crawford.
Your Honor, as I have stated previously, I have to do what's in the best interest for my client. And for my client, they feel that this claim file is, proprietary information that is based for the insurance company and their evaluation, and they're looking at it. I know Mr. Phenix has talked about wanting to depose certain individuals. He has the information for the claim handler, who is the main person that makes the decisions, as well as everything's run through their team manager. If a deposition is going to go forward, the person that's going to be deposed is going to be that team manager, which we have provided him the name of that individual. It doesn't change. And if it does change, then a letter is provided to the insured in this situation, the plaintiffs, Mr. and Mrs. Mills. They were given the new name of the new handling adjuster, but throughout this entire case, well, not the entire, towards the end, it changed to a new adjuster. Her name was Heather. And prior to that, it was Michael Balla. And we have provided that information to Mr. Phenix. So to look at this claim file is not going to, looking for names, it's really not going to include any additional names. Every communication that is made with the plaintiffs was produced in letters, as well as it has copies of when they send out they call it a text message, but it's through the claim system, and it's produced in a document. And I have produced that to him. Finding any additional information from the claim file, he's pretty much got everything. Every communication that was made was either via email or letter, or, as I said, this text communication system that produces out a letter that that I have produced with correspondence with my initial disclosures, which is what I have put forward. As far as going back to the claim file, insurance companies protect the way that they handle their claims from other insurance carriers. So in this situation, they are looking at it as it is trade secret, business related privilege. And I don't see any reason how this needs to be produced and that it's going to further the handling of this claim or settlement of this claim.
Do I need to respond to that?
No, no need. All right, I'm gonna overrule the objections to 2, 3, 4, and 5 and order the matters requested therein to be produced, specifically the enterprise claim system documents, as well as or claims narratives.
And Your Honor, on exhibit, request for production number 9, I just need kind of understanding on there's a response, and then they do a first supplemental response, and the response has an objection in it. And actually, I think on number 9 we're fine with that. I'm going to flip over from that one.
All right.
But on number 24, there is an objection on it, and then there's a response. And so I'm with no objection. So I'm trying to figure out whether or not on the way that Ms. Crawford's done this, or State Farm has done this, whoever did it, is making this response is when the supplemental is there, are we waiving the objection, or are we still urging that objection?
Still urging the objection. With the supplemental response, it is listing out every payment that has been made under the to the insured under this claim.
All right, so, I'll overrule the objection.
Okay. And then the same thing, I guess, on number 25, I'm looking to see if we need to get the court to overrule that objection on number 25.
All right, I'll overrule the objection on number 25.
And then to the same thing on 28. And 28, actually, there's an objection, but there's a will supplement. I need to get that information. And let me tell you, this is something else that's in the claims file. That's in the other claims file is a alternate workflow program. And so what's happened, State Farm has developed an alternate workflow program that deals, and he's placed Burroughs Collision Center on that alternate workflow program. So what happens is when it goes to Burroughs Collision Center, the customers get, or the people making a claim get special treatment. I've deposed Leah Luvender on this in the Collins case. And then, but there's documentation that they sent out special letters. They've got special people that handle this alternate workflow program. And they're totaling vehicles at a different rate under the alternate workflow program than they would otherwise. And they're doing it midstream after they started repairs on it, which really puts the claimant in a disastrous situation because they're totaling vehicles when they're halfway repaired. And so we want to be able to explore that because those are issues of bad faith. Those are issues of unfair claim settlement practices and differences in the way that they are treating customers who choose to use an independent body shop, which is actually prohibited by Texas law. And it's when State Farm sends a claim, says they can't discriminate against people because they choose an independent body shop, but yet they're doing it. And so we would, the alternate workflow program is request 28, 29, and 30 we'd ask the court to overrule those objections. And I think also, let me see here. Yeah, that's 31 as well.
Your Honor, on those, I mean, he's asking for information on all letters for not just this claim, but for all claims for individuals who are not related to this. That's private information. And then he's asking for information on all the names, addresses, and telephones going back for everybody that's involved in this. I don't even like. That's a lot of information. How is that supposed to benefit this claim? That has nothing to do with the decision making in this specific case. And he talks about how State Farm totaled this vehicle within a month of this accident. This accident occurred on July 11th, 2022, and State Farm looked at it and totaled the vehicle on August 11th, 2022. And they continued. The entire repairs to the vehicle were not completed. The estimate for these repairs were finally sent not until, not until September. So they had already totaled this vehicle, and they did not state that they could not repair the vehicle. They said, fine, if you want to have your vehicle be repaired, that's fine, but we've already totaled it. We're going to take the salvage cost out of it. So you can have it repaired, but we've already totaled it and the salvage cost off of it. And they submitted it to an appraiser, and State Farm which increased it by just under $2,000, and they kept the salvage price at the lower rate, so that way the insured would have more money. State Farm had already came forward and said, hey, we're going to total this vehicle. And then moreover, going in for what Mr. Phenix was saying, that they're treating them as, these alternate workflow program. Yes, they're not like they're second rate. No, there is a lot of evidence going back between State Farm and Burroughs Collision. They do not meet eye to eye, and that there's a lot of evidence on that in other cases. And this is the issue. They have a higher rate for things than other estimate facilities. That is why Burroughs Collision and State Farm go head to head, because insurance companies are going to pay what the reasonable market value is for repairing the vehicles. Burroughs has a higher rate, so yes, they do butt heads. However, in this situation, they went back and looked at it and they said it's a 2010 Toyota 4Runner. They looked at it, they valued the vehicle, the repair cost. They ultimately valued this vehicle. They appraised it at $22,400, and the repair costs came back at $19,613.51. I mean, that's almost the entire amount of what the actual value of the vehicle is. So in this situation where he's wanting on this alternate workflow, saying that there's some situation where they're taking these insureds and they are treating them as second rate because they're choosing these other repair facilities, there's no proof of that. This situation in this accident specifically is on looking at the appraisal and the repair cost. This alternate workflow program, whether they were a part of it or not, is not an issue. So having us produce information on the alternate workflow does not make any sense for this situation. I mean, I don't even know about this alternate workflow program. I mean, he's asking for information on and documents and letters that they're required to send, when I haven't seen any evidence that there is any such documents. So requiring us to produce that, where is that there is going to be any of this evidence?
Your Honor, if you'll give me a second, I'll give you some evidence of in other files of the alternate workflow program. that, let me see here just a second.
I have reviewed this. There is 2 mentions for Burrell's collision, and it has this AWF next to it. That is the only thing that is ever mentioned in this claim file.
And Your Honor, and I'll just represent to the court. I don't think I need to show this unless the court wants to see it. But in the Ashmore claim, and then also in the Grigsby claim, if you get in the claims file and just do a computer search for AWF, it's all over it. It's all over it. And we've already deposed.
Are both of those Burrell's cases?
Yes, absolutely. Yes. And I'll do this. I think Ms. Crawford has a good argument as it relates to exhibit request number 29. They've already said they're going to supplement on request number 28, but they haven't done it. And then on request number, and when I deposed Ms. Lubender, she said, we've got special scripts and we've got special letters that we send to body shops like Burrell's that are on the program. And so those special scripts are trying to steer them to different shops. And then those special letters are putting information which I think was absolutely proven false in the Joe Collins case by their corporate representative who appeared in the courtroom and said, and the stuff that Ms. Crawford, that State Farm has been feeding Ms. Crawford about this, has already been testified that that's false in the Collins case by their own corporate representative.
All right, so what are you saying?
I'm saying that
you referenced 28, 29, and 30. So what are you saying? You referenced them, but then that's all you did.
On 20, 29, 28, and 30, I would urge those on 29, I would draw that one, Your Honor. That's the one that asks for letters that are written through the alternate work program. That's
28. You've already said Ms. Crawford said you would supplement that.
That's correct.
All right, go ahead and make your supplement on that.
And I'd ask the court to overrule the objection that she's made on that one, which is the same objection that she's copied under number 30 as well. And then on 31, we'd ask the court to order that produced as well. And that's the people participating in the alternate work program. Because I need to know who they are so I can depose them.
All right, here's what I'm going to do. All right, I'll overrule the objection, order it produced on 31. On the remaining, at this time, I'm just going to order it produced and in reference to Burrell's for the rest.
Yes. And that's all I want is whatever's referenced to Burrell's.
And let me go back.
But I think the program is the way I understand the program is when a Burrell's or shop gets it, then they've got a special set of letters that they send, and then they've got a special script that they talk to their clients about.
Yeah, and I'm just ordering not for everyone, but just for Burrell's.
Okay.
Okay. All right.
Does that, Your Honor, does that apply to the individuals in request for number 31?
No, I'm granting in the entirety is to 31, but that's just the name, address, and telephone number of the individuals participating in the AWF program.
In
totality.
Okay. If that comes back to be a larger list, I mean.
Well, if it's something, you can return to the court on that without any bad thing.
Okay.
All right.
Because I mean, Your Honor, I do not know at this
I understand.
present, I do not know the amount of names or if there is a specific AWF program.
All right.
Based on
nationwide or if it's Texas, just specifically Texas. I do not
Well, I'll tell you what, since we're dealing with, I'll restrict it to Texas.
Okay.
All right.
And Your Honor, in reference to producing the claim file, that's taking out any attorney-client privileged information.
Yes.
Is okay.
Yes.
And I think that gets us through the request for production, and then we jump over to the interrogatories. And I've got an answer to number one. I just need a ruling on the objection because I don't want to get.
I gotta get to the interrogatories. All right. All right, I'll, since you've answered, I'm gonna overrule the objection. Okay.
Then to number 4, I need a ruling on that objection.
All right, I'll overrule the objection.
Then to number 6, I need a ruling on that objection.
I'll overrule the objection.
And then to number 11, I've got a supplemental response. It looks like I just need a ruling on that objection.
I'll overrule the objection.
And then to number 13, on that one, I really didn't get a response. And I've got describe all letters written to State Farm insured on the alternate workflow program.
Well, I think my on the request production will take care of that.
Okay. And so I'll just, I think I agree with you, Judge. If we got the letters produced, we probably don't need a response to 13. So I'll take that one down. And then I think on number 15, we've got the name, address, and telephone number of a person who's engaged in the organization of the alternate workflow program, development of the alternate workflow program, and all current participants in the alternate workflow program.
And then the request production should take care of that, I think.
Well, and it may, this may be a little bit different, Your Honor. I'm thinking on the request for production, if that's not in some kind of document that has those names, that we might need to have that in an interrogatory. It's the only thing I would say.
Any documents that we produce will most likely have all the names listed.
If it does not, Mr. Phoenix, come back to the court.
Okay, I'll do that. And then to number 16, I'm asking for the date upon which it was formed.
I do not have that information at this time, and I put in there that I will supplement as I have requested that information.
I'll order it to be supplemented within 30 days.
And could we get a ruling on that objection as well, Your Honor?
That should be overruled.
Okay. And then 17, we're fine with. I think that was in our motion. 18, we're fine with. 19, I'm okay with that. Just need a ruling on the objection on 19.
All right, objection be overruled.
Okay, and then on interrogatory number 22, we're good with that. So, and 2023, I asked for the total cost that to State Farm of preparing a market by CCC1 market evaluation report.
Your Honor, I don't see how that is gonna has any bearing on this claim. Finding out how much.
What is the I don't know, what is the CCC one market
The
valuation?
CCC1 market evaluation report, State Farm has and you'll remember from the Collins trial, State Farm has an algorithm that they use.
I don't remember last week, but go ahead.
They have an algorithm that they use that it's our position that it habitually undervalues the vehicles. It's got false information in it, things of that nature. And they have a responsibility to investigate the value of a vehicle, especially if they're going to use that value to determine a total loss. And so they can go hire an appraiser. We have that number, what they paid for the appraiser. We also need to have the number for the CCC1 report to see that they're putting profit above
It
getting
just
right.
pertains to this claim.
Yes, this claim.
I'll order that answer pertaining to this claim only.
And I think that's everything we have, Your Honor.
All right, and I'll carry the claim, the request for attorney's fees in this matter, and note that, and put that in the order.
I'll do that. I'll do that as well, Your Honor.
All right.
Okay. Jennifer, good to see you.
Thank you. Y'all have a good weekend.
Okay. Thank you, Judge. You too.
Thank you.